The Democrats moving forward with their contempt charges against Attorney General William Barr. Now, one of the problems with this contempt charge is that it's really, really stupid. So as David French, the legal analyst at National Review, pointed out yesterday on our radio show, David French pointed out William Barr originally had no obligation to turn over any of the Mueller report. He decided to turn over virtually all of the Mueller report. In fact, when I say virtually all of the Mueller report, Jack Crow over at National Review reports that top Democrats now have access to all but 2 full and 7 partial lines of Robert Mueller's obstruction report. He says, as Congressional Democrats prepare to hold Attorney General William Barr in contempt over his supposed lack of transparency, it's worth remembering he has made available to top Democrats the entirety of Volume 2 of the Mueller report, save for 2 full and 7 partial lines, which were redacted to protect grand jury secrecy in keeping with federal law. In order to provide lawmakers with greater transparency into Special Counsel Robert Mueller's investigation, the Department of Justice placed a less redacted version of his report in a secure room on Capitol Hill and granted access to that room to congressional leaders of both parties, as well as the chairman and ranking members of Intelligence and Judiciary Committees in the House and Senate. As of this writing, not one of the 6 Democrats granted access to what amounts to 99.9% of Volume 2 of the Mueller report, which details the president's behavior as it relates to obstruction of justice, have taken the opportunity to examine it. So just to get this straight, they have now made available to top Democrats the entirety of the Mueller report, with the exception of 2 full lines in 448 pages, 2 full lines, and 7 partial lines. Not one Democrat has done this, and they can. They have the option to do so. If they had, they could have viewed the entirety of Mueller's obstruction case against Trump, except for 7 redactions, 2 of which are applied to footnotes. In response to Barr's offer, Congressional Democrats have said the full report should be made available to all lawmakers. Why? They won't even look at what's there. Now, the reason they won't look at what's there is because if they look at what's there, then they will have to admit that there really isn't much additionally that is there that is damaging to the President of the United States, undoubtedly. They say the full report should be made available to all lawmakers. They've argued the outcome will become less likely if top congressmen view the less redacted version. So in other words, if they go and see the less redacted version, they're afraid the argument will be taken away from them that Barr is being non-transparent. Well, that's because Barr is actually not being non-transparent. He's being quite transparent here. Mark Warner, the ranking Democrat on the Senate Intelligence Committee, told John McCormick, every member of Congress ought to be able to see that version. I think if I were to go, you'd lessen the case. But Democratic leaders are not asking for that version, which retains the grand jury redactions. They're asking for a fully unredacted report and all of the millions of pages of underlying documentary evidence, which relate to 22 ongoing criminal investigations. Now, as I mentioned yesterday, it is against the law for William Barr to actually comply with this subpoena request. Federal Rule of Criminal Procedure 6E prevents the disclosure of grand jury information. Federal Rule of Criminal Procedure 6E is not unclear about this. In fact, it's quite clear about this. It says that you are not allowed to reveal all of this stuff. You cannot do that because if you do, you could be exposing to both criticism and censure people on the basis of non-evidenced theories that are often put out there in grand jury testimony. According to Rule 6E, secrecy must be the rule of the day. Once a grand jury is summoned, you are not allowed to put out the information that is said in the grand jury summons. You can't do that. So this is ridiculous. Basically, the Congress created Rule 6E. Okay, Rule 6E is a congressionally created rule. The fact that Democrats are now saying that William Barr should be held in contempt for obeying the law is pretty insane. According to Rule 6E, no obligation of secrecy may be imposed on any person except in accordance with Rule 6E2B. Unless these rules provide otherwise, the following persons must not disclose a matter occurring before the grand jury: a grand juror, an interpreter, a court reporter, an operator of a recording device, a person who transcribes recorded testimony, an attorney for the government. Not allowed to disclose a matter occurring before the grand jury. Disclosure of a grand jury matter may be made only to an attorney for the government for use in performing the attorney's duty. Any government personnel that an attorney for the government considers necessary to assist in performing that attorney's duty to enforce federal criminal law, which does not apply to Congress, or a person authorized by a different section of statute, which does not apply to Congress. There's no question that Barr's interpretation of this rule is correct. Nonetheless, Democrats are attempting to hold him in contempt For what exactly?